Hello and welcome to Newshour Direct, and joining me tonight is senior advocate Saurabh Kirpal, the man who's written a book on 15 judgments, cases that shaped India's financial landscape. Thank you for joining me, Saurabh Kirpal. And many people have stopped talking about courts, judgments that are pending and the judgments actually that have impacted the economy. What really made you write a book on why these financial landscape impacting judgments and how they've changed investments in this country and the consequent unemployment issue that this country is facing?
First of all, thank you for having me here, Navika. I think one we must realize is that a large part of the reportage on the court is largely about matters relating to public interest litigations and other political statements that the courts make. But the real fundamental job of the court, and that is what it does every day, is deciding issues between private parties, right? That is the function of the court really. PILs and all are side things, but the real core of decision making is financial and other adjudication that happens in court. And I find that the large number of Indian public is completely unfamiliar with and unaware of what the courts are actually doing. So this was my endeavor to write a book in simple language that would familiarize people about what is it that their courts are doing, right? Ultimately, the courts are a public institution. We are very proud of our courts. And that is why the public must be aware of how they function and what they are doing. So it was very important for me to write this book to give the perspective to the common person as to how their life is impacted by the courts. You mentioned about unemployment. Now, there is a large amount of decision making that the courts do which have a direct impact on employment, etc. For instance, take the case of environment versus the economy, right? Every time the court gives a judgment in favor of the environment, it has a negative effect on the economy. So when you stop mining, you will also stop generation of jobs. Now, that might be a justified decision on the part of the court to stop mining because that has an adverse effect on the environment. But does the court have the wherewithal? Does the court see the effect financially its decision has on the economy of the country? And is the court not required to look into these things? So that is an aspect that I thought I should write about and at least start a debate on these issues, that every time the court decides, there must also be some kind of an economic impact analysis of its judgments.
So far, are courts doing that? Because after all, the courts in this country are put on a pedestal, as they should be, because the Supreme Court of India or the high courts are the final arbiter of disputes. But do you think they are really going into all aspects that can impact people of this country, number one? And number two, the biggest question that has been an age-old debate: who's taking the decisions in this country, the Supreme Court or the legislature?
Both are very important questions and, of course, very intimately tied together. I'll answer the second question first. The decision making is meant to be taken by the legislatures, right? The court was always meant to interpret legislation, not actually legislate. In some instances, when the court felt that the legislature was not doing its constitutional duty and legislating on matters that were relevant, the court could step in, right? For instance, the Vishakha case, and that is one of the chapters I deal with in my book, that for after independence till next 40-50 years, there was no law which related to sexual harassment. So the court had to step in and say, you've had plenty of time, Mr. Parliament. You have not actually done anything about a matter which is vital to the livelihood of women in our country and has an impact on the economic empowerment of women. So we will step in, right? So those instances I can understand that the courts will actually decide matters which have an economic impact, but are otherwise in the domain of the legislature. But now we come to the first part of your question. Do the courts actually always examine the economic impact of their decision making? Answer, no, because they do not have the wherewithal, right? Even if we don't like legislature, even if we don't like the executive, the fact of the matter is they have tools at their disposal in the form of papers, discussions, access to the electorate, which a politician does often have. The job of the court is to only interpret the Constitution. The court has access to the Constitution, which is the ultimate grand norm, ultimate basis on which laws are to be examined. They do not, however, have access often to information which exists with politicians and bureaucrats, so they are constrained somewhat in their decision making. That does not for a moment mean that they have to abdicate their responsibility and stop deciding, that they do not have this information, so we will not decide. What is relevant is, and what is important is, maybe the court should start now asking that this is a decision we have given. Let us have an audit of what has been the economic impact of that particular decision. For instance, take the example of the telecom licenses. They were all cancelled after a fair degree of scandal and or corruption, etc.
And 122
but
of them.
Was that cancellation strictly necessary? 122. In the meanwhile, those licenses have been bought by foreign companies. They have paid good money. They did not know at any point of time that these licenses were tainted by corruption. They were not to blame. But when the court decides, it used a sledgehammer approach and cancelled all licenses. It stopped the growth of the telecom sector in this country. It had a massive impact on employment generation. So all these factors are not even discussed in that judgment. So that is something that is very, very difficult to accept.
But also the issue of CAGR, the revenue sharing that was happening with the government, on which the Supreme Court took a few decisions which put all the telecom companies into the red. The fact of the matter, Saurabh Kirpal, let's just come to the bottom line. In our country and in the present day age of social media, television, broadcast, digital, do you think every side is playing to the gallery and there is a game of one-upmanship and a bit of, heroics that is going on? I don't want to go in for contempt, but on part of the judiciary as compared to the legislature as well.
Let me come to the defense somewhat, only somewhat, of the judiciary, which can't actually defend itself often. It is true that there is a lot of sensationalization and statements that courts make, which are reported in the media on the next day. Some of the statements may be made with the intention that they approach the media. But I don't think that is largely true. You see, when an argument happens in court, there is a discussion and a dialogue between a judge and a lawyer. A lot of questions are posed by the judge in trying to achieve the correct decision. Some of those questions may sound sensational, but may only be clearing a doubt in the mind of a judge. Unfortunately, because of possibly some reporters not understanding this nuance, they rush to the papers the next day. Now, it might be because they don't understand this nuance, or they may have some other interests to show a particular view that the judge has taken. And they start reporting as though what the judge asked in court by way of a question to clarify a doubt was the final view of the judge. Now, that is not fair to the judge, because that freezes dialogue. If the judge keeps quiet and stops asking questions because they're worried about what will be reported in the media the next day, you will not get a complete decision. Just in the earlier point, I said to you that judges don't have enough information about the economics. If they don't even ask the questions because of the effect of the next day's media, then there will be even lesser information amongst judges. So I would counsel caution on both. The judges must not make statements which are unnecessarily sensational. I don't believe that they do, but to the extent that they do, they must not. Equally, I think it is very important for the media not to cover every word the judge says. That is also not a positive sign. Please report on the final judgments. That is how it is in the world across. You see the US Supreme Court, their proceedings are live cast also. But you don't have the same discussion in the media in the US about which judge said what, etc. That they decide the ultimate judgment. So please decide a judge on the final words that she or he has made.
Well, Saurabh Kirpal, very easy to point the finger towards the media. But let me ask you, in an age where we are talking about a direct telecast of the live proceedings in a court, you don't need reporters to report it. People are watching it real time, live, through the streaming that's happening. Now, in the middle of that, if there is a banter between judges on the bench and the lawyers, a few days ago, one noticed something of the kind where they're talking about, something extremely trivial about, even women, said in a way that possibly, would get feminists, and even if you're not a feminist, general, regular women also up in arms. The question here is, banter, is the courtroom the place for banter? Is the courtroom a place for sensationalizing and then blaming the media? Is that the standard operating procedure?
No, absolutely not. Look, I was commenting on one side of the equation about media's role. But it is not at all my intention to say that the judges always get it right. Very often they get it wrong. And the judges really should exercise much greater restraint, especially if the proceedings are being live telecast, for the reason you said, that there is now no editorial intervention between what the judge says and what the viewer sees. It's instant and the people make up their own minds. So the responsibility is even greater on the judges now to make sure that they are occupying august offices. They're meant to be seasoned people. They're meant to have a certain gravitas about them. They must maintain that gravitas in court. A little banter, a little joke, just to keep the atmosphere of the court light is one part of it. But I think some of the statements of the court do show the regressive mindset. The example that you gave just now, I think that slipped out of court, and perhaps it was a good thing, because we will now next time ensure that the judges don't say something. When the negative reportage happens in media, maybe judges also go back and think and reflect that what they have said is wrong. So it's important that media report it. What I'm saying is that a balance has to be drawn, and without doubt, judges must exercise much greater restraint than they do. They don't. Asking a question about law is the banter I'm talking about, and in that you may ask a question which is uncomfortable. But to make extraneous observations, that is unnecessary, and that should not be the practice at all.
Well, Saurabh, on the 15 judgments, to your mind, which is the most important judgment, apart from the 2G1 that you've already mentioned, which has impacted the financial landscape in this country?
That's rather like asking a father to choose his favorite child. But if I were to choose a favorite or the most impactful judgment, I would say the very first judgment in the book. It dealt with the right to property. And it's something quite interesting what happened in the Constituent Assembly and before the first parliament was even the elections to the first parliament. There was zamindari in this country, and the courts gave a judgment saying that if you abolish zamindari, you have to pay adequate compensation to zamindars. Now, the moment that happened, the Constituent Assembly, which had given a series of rights in our constitution to the people, could not fathom or bear the fact that those rights had actually been exercised by the people for whom they were meant. And before the first election happened for Parliament, the very same Constituent Assembly amended the Constitution wholeheartedly and removed a large part of fundamental rights. They removed fundamental rights not in relation to just the finance and the right to property. There was dilution of the right to free speech. There was dilution in terms of reservation, etc. as well. And it just showed that it has always been the case that there is a tension between the executive and the legislature on the one side and the courts on the other. This is happening from the 1950s till now. But what happened because of that judgment was constitutional amendments which gave the courts, which gave the legislature the power to introduce all kinds of legislation where the constitutionality of which could not be judged by the courts by way of Article 31A and 31B of the Constitution. So the moment something is put in the schedule to the constitution, the courts can't look into that at all. So the court's judicial review was ousted, and that has had a dramatic impact thereafter. For instance, matters like FERA, the Industrial Dispute Resolution Act, all these judgments have not been examined by the courts because of the First Amendment, which was product of the first judgment.
Courts and the legislature have often been on collision course, and we've seen that in many times. But Saurabh Kirpal, in current day world, where institutions are continuously debated and questioned in common parlance on social media, do you think we are entering a phase where institutions are actually, and their basic edifice is being eroded? It's a question that has often been raised after 4 Supreme Court judges came out into the open with a press conference. You know, people at one level said, very good, they should be able to come out and speak. On the other side, people said that, this is the end of the revered judiciary. Where do you stand on this entire debate?
Look, I believe that any kind of discussion and debate can never be bad. Every institution should be subject to public scrutiny. The way the courts scrutinize the legislature and the executive for their actions, it is imperative that the judges also be judged. You can't be in a silo of complete secrecy and in your ivory towers and expect that no one will comment on your conduct. It is important that people do comment, right? In that comment, there will be excesses, which you have adequate tools by way of contempt and defamation to control. So the same tools that seem to work for everybody else should also work for judges. The one difference is that judges cannot come out in the public and defend themselves, because then they will be dragged into a kind of a tutu meme, which is not an edifying spectacle for any judge. In any case, a judge is deciding a dispute between two other parties to which she or he is not concerned. So how will that judge ever explain why they took that decision? And the reasons for the decision are often contained in the judgment itself. But that does not mean that they should be scared of social media, right? After all, we live in a world where all of our lives are examined in social media. So there is no reason why what judges say and do should not also be examined by social media. So that is external comments on judges' own decision making. The question that you posed about that press conference is as to whether judges themselves should have a press conference and speak to the public. I believe that there should be greater reticence on the part of the judges to speak about what is happening within the system. Their final verdicts should speak. Their final decisions should speak. They should not move this domain of discussion, which is about all kinds of privileged and confidential things, into the public domain. Because if you do, then you cannot stop comment and dialogue on it, right? It's not fair to say, just hear what I have to say, but don't question me thereafter. Because if you say something, you will be questioned, as you should be. So it's best not to say.
So the principle of transparency, should it apply to all other parts of this Indian democracy and not to the judiciary?
But of course, transparency must apply to the judiciary. I think it's too closeted just now. For instance, I, for one, believe that Collegium decisions should be, reasons should be given. There should be discussion which is widespread. This aura of secrecy that is there around the Supreme Court and other courts in general is completely outmoded. It's not the correct thing today. So that's why I think this transparency, which, as I said, if the court expects transparency of the executive and the legislature, the people of India expect transparency of the courts. I think, therefore, this live streaming, for instance, that has started of court proceedings is one very good way of ensuring that the common person finds out what is happening in the courts. After all, we talk about the Collegium decisions and appointments of judges, etc. That's one part of what the court does. The vast, more important job of the court is to make decisions about issues and matters before it. So the court public persona and it being live streamed is very, very important, so that people can see it, and that's the transparency that is important.
And how can the Collegium system, the NJAC was struck down. it was somewhat of a step forward, which the courts, the judiciary disallowed completely. And now we have this complete cloak of secrecy. How can it be broken? And you yourself are a victim of the Collegium system. How do you take the fact that in 2022 we still have, it's not a, if you look at the court, 377 has been decriminalized, but in actuality, the courts are the first place where it is becoming unacceptable, as in your case.
Well, as regards 377, the courts have cleared my name, but it took them 4 years to do that, right? So my name was only cleared by the Supreme Court last year in November, after almost 3.5 years. Why did that take that long? I do not know. The courts should be faster in taking decisions. But the matter now rests with the government, which will examine it, I hope, soon. It's not good to let decisions linger one way or the other. You must forward yes or no. But your question earlier about the NGAC, I am a firm believer in requiring the participation of government in appointment of judges. I don't think every time the government says something about appointment of a judge or gives an input, it's not that the independence of the judiciary is shaken. The independence of the judiciary rests on the personnel manning the institution. If you have good people sitting as judges, they will be independent regardless of who appointed them, right? And it is not as though since the last 30 years of this experiment of judges appointing other judges that the country has witnessed a terribly independent judiciary any more than it was prior to that. So I think that the NGAC judgment was wrong. The NGAC was an experiment that should have been allowed to function at least for some point. But unfortunately, that was not the case. I hope the court will revisit its judgment and allow some input on the part of the government, which is a stakeholder in appointment of judges, to consider the appointment of judges.
But the question here is, courts are supposed to go by the constitution, and the land that we live in, which is the largest democracy of the world, courts really are the final arbiter of whether or not justice is granted. So in the Collegium system, where you said 3.5 years, the courts took to clear your name, and now for the last 1 year, the government is sitting on it. Do you think you've got justice in this country? And if you as a legal luminary have not got it, what about the common man?
Look, as they say, justice delayed is justice denied. But I don't think that is the truth in my case. I think I stand for a particular cause, and if it's taking time, it's taking time because mine is a novel situation. And I am a believer in evolution, not revolution. So if it's taking its time, let it take its time, as long as the correct decision is ultimately taken, right? Every time there is change that happens in courts, we have seen it takes its own time. And that's something that we accept. It's a constitution to which we abide by, part of which is the courts with their own systems. So I have no option but to respect that. And if it takes time, it takes time. I can only beseech those who are in power to take decisions more quickly. But I cannot do more than that.
No, but, everybody has a working span, and decisions that are delayed also take away the right of a person, to fulfill his career ambitions in a particular period. So I'm saying, isn't it unjust? It's very well for you to say evolution, not revolution, but certainly I'm asking this from the common person on the streets perspective. What does he get? Is he assured justice in this land or not?
Without doubt that if justice is delayed, there is no question of that being a fair decision, right? One is, of course, the economic judgments that you see, and that's true. But what about a person who's languishing in jail, right? If the matter does not go to trial and you are sitting and in custody waiting for your matter to be decided, that is not justice. So the courts need to devise systems which are faster. In that, of course, even the government is a stakeholder because courts alone can't expedite decision making. The government must also give more money. But again, I don't want to exonerate the courts from this. There is a responsibility of the executive, that's correct. But even the courts must be conscious of the kind of matters they take for decision and prioritize those matters which impact people's lives far more than other matters of public interest, which may impact only the interest of a few people filing those PILs, right? So the court, I believe, must go back to its original function of deciding boring old cases rather than deciding cases which make a splash or a headline.
But do you think they do that, or do you think headlines, however much you abuse the media, are something that bring a zing to everybody's life?
Look, they're judges and they're judges. I'd say, to be fair to a large number of the judges of the higher judiciary, they are not concerned with the headlines. But that's not to say there are not some judges who are. Undoubtedly, there will be some judges who will be playing to the gallery. But I think we forget sometimes how much work judges do. For every sensational case that is reported in the press, there are 50 to 100 judgments that a judge gives which are not come to the public light. So there is a lot of work that is done by them already.
Fair point, fair point. Before I let you go, Saurabh, I also want to ask you, while you mentioned the 2G cases, the mining cases, and you've written about the Balco case and the Industrial Disputes Act, I want to ask you, there is a politico-economic question that continues, to be in the forefront of all politics, which is the demo in 2016. That case still pending. Places of Worship Act still pending. Religious conversion still pending. How do you think the courts are behaving on all of these matters?
That's something I touched on already. The courts must prioritize those cases which are of the utmost public interest. And I think those decisions of priority lie entirely in the hands of the Chief Justice, because the Chief Justice is the master of the roster. And I must say that some of the previous Chief Justices have not done, in my view, a correct thing in not prioritizing these matters that you mentioned, of which are of immense public interest. I can only hope that the new Chief Justice does put these on the fast track. I also believe that this power that is given to the Chief Justice alone in constituting the roster and deciding which matters are prioritized is not a correct thing. Just the way that the Collegium decides who should become a judge, there should be a participative decision making in deciding which cases should be heard, so that no finger is pointed at a particular Chief Justice for a decision she or he has taken. Actually, he has taken. We've never had a female Chief Justice. Also, a variety of inputs come in as to which are the truly important decisions that need to be considered.
Well, now that you point out, yes, 75 years and counting, and we haven't had a female Chief Justice. What's the message that sends to our society?
I think a very negative message. It shows that the courts and all those who are in power trying to appoint judges have not been fair to the women of our country. Forget the Chief Justice, that is the titular head, right? That's one person. But of the 34 judges, there are barely a few judges who are women. And that's in the Supreme Court. If you go to the High Court, the position is even worse. There must be equality of opportunity, which is reflected ultimately in equality of the number of judges we have as women and men. Someone once asked Ruth Bader Ginsburg, the very celebrated judge of the US Supreme Court, saying, how many judges of the Supreme Court should be women? How many do you think is enough? And she said 9, right? And there are only 9 judges. Now, the vast history of our country, we've had only all male judges. Why is it that we think that having only women as Supreme Court judges is something that is beyond the pale of possibility? So I think the message that is gone by not having a female Chief Justice and not enough female judges is that it is not an easy task for women to be lawyers and to work, and extra effort that is required to push women to achieve the equality which is otherwise denied to them has not happened.
But Saurabh, is it also because debate has not been allowed on issues like this, because there are two very strong instruments, actually one, which the judges hold in their hand, which is contempt?
I am also a firm believer that the power of contempt is used excessively in our jurisdiction. And more than the actual use of contempt, because there are not very many judgments which have come of contempt, it is the threat of contempt, right, which is bad. So I think there should be now a consideration that certainly the law of criminal contempt should be amended, and there should be no criminal contempt except in the most rare, egregious circumstance. For instance, if someone comes to court and throws a shoe at the judge and starts abusing a judge, I can understand that because you can't really function as a judge if that is what is happening. But to say that, oh, he made an insinuation against a possible way of a decision making, or these are not matters that should be dealt with by contempt. These are matters of fair public debate which court must welcome.
Well, just as you've written a book on the 15 judgments, cases that have shaped India's financial landscape, I'm hoping and I'm wishing you the best with your pen that you, in your next book, pick up some of these contentious issues beyond the financial space, which actually get into the social and the political landscape of this country, where many issues need to be debated threadbare, because transparency in today's world is the minimum that this country would want from the judiciary. Thank you very much, Mr. Saurabh Kirpal, and all the very best for this book that you've written and for the many more we are hoping you'll be writing in the near future.
All the judgments that I might be writing, let's see.
Thank you for joining me on Newshour Direct.